Wait, my lord, I beg to mention in item number 33, my lord, an affidavit has been filed by my learned friend yesterday. And my lord.
No, what do you want? Adjournment?
Yes, my lord.
It's adjourned. Yes. Next.
Next, I'm obliging.
Beg to mention item number 29 is the consent of the other.
Adjourn. Please give your name and your item number. Any more?
Can it be next week? I am the applicant
Sorry.
for the stay vacating petition.
We can't do that.
Next week.
Either we take it up or registration.
Or I have to mention again, perhaps.
Whatever, whichever we prefer.
My lord.
Or we don't mind taking you out today also. We have no difficulty.
They have a difficulty.
What to do?
My lord.
Yes, Madam Secretary.
His Lordship, yesterday I have found a judgment, my lord, of yesterday's case, my lord. But I again tried, my lord,
Yesterday's
that
matter,
also-
is it in the list?
So, my
today?
lord,
Next day.
no, it is after vacation, it is given. So next week, if it is listed, it can be disposed of, my lord.
It cannot be done like that, Madam Secretary. A
Because
judicial
this
order
fully
passed
covered.
fixing a date cannot be changed at a mentioned at 10:30.
My lord, I thought, my lord, that since
No.
your lordship has had again,
No,
my lord,
even
it will go to
even
some
if
other
the-
bench, again complication, my lord.
No, even if you have thought about it, we
Yes.
can't change a judicial order by means of a mention at 10:30.
So it cannot be prepared, my lord.
Definitely. Or
Your
else you
lordship, please, my lord.
file an IA, we'll bring it. IA.
IA.
Huh? That's the only way out. Yes, next item, please.
Item number 46 and 47.
Otherwise, we should not disturb a judicial order. We can't do it. It will be contempt on us only. Yes,
Item number
okay.
46 and 47. my lord.
46, 47. What do you want? Adjournment?
Only for today.
Answer my adjourned. Yes, sir.
Item number 48 as well. I've taken the consent. Maybe adjourn.
Sorry, 40 adjourned.
40. 48. Item 1 for withdrawal.
What is your name?
C. Talukdar.
C. Talukdar. Your name does not appear.
I am appearing on behalf of
There is cannot be withdrawal on behalf of.
T.K. Bhuya.
Ask either of the four counsel to come. Whosever name appears.
He is
Yes,
on
next item.
briefly of this.
If you come, we will call it again. Otherwise, adjourn. Yes, item 2. Yes, item 2.
Item 2 for motion.
Yes, my lord.
And Mr.
This is a matter after some notice yet to be issued.
For instruction, my lord.
No instruction, nothing. What is the matter about?
My lord, compassionate appointment.
I'll give a date.
Was it placed before DLC?
My lord, yes, my lord.
Which page?
DLC rejected, my lord.
Page number?
36, my lord.
36. Which serial number?
Serial number, my lord.
Moidul.
Yes,
Moidul is serial number 1.
Yes.
DLC discussable could not consider due to underage at the time of application. Yes, same order. Heard Mr. A. Mohammed and counsel for the petitioner also heard. Please say here. Anybody else? Education department.
Second day is there.
Anybody appear for Mr. U. Sharma for the education department?
1, 2, and 4.
For the secondary education department. The father of the petitioner. What is the name of the father?
Silamat Ali Ahmed.
Siramat Ali Ahmed, who was working as an assistant teacher in the Pazar Bhanga High School in the Borpeta district, died in harness on 31/7/2015, and on his death, the petitioner made an application for compassionate appointment on 6/8/2015. The said application was considered by the DLC of Borpeta district in its meeting of 17/12/2022. And it stood rejected by providing the reason that at the time of when the application was made, the petitioner was underage. The law in this respect has been settled by the Supreme Court in NC Santosh, where in paragraph 35, it is provided that the norms prevailing on the date of consideration would prevail. Admittedly, on the date of consideration on 17/12/2022, the petitioner had attained majority. In view of the above, the rejection by the DLC set aside, remanded back to the DLC Barpeta for considering the petitioner on merit as per law.
Item 3.
Yes, madam. Item 3, what is this matter?
Matter is compassionate appointment.
DLC.
My lord, it was never placed, my lord.
Heard MSSB Chaudhary Land Council for the petitioner also heard. Education department.
Yes, my lord.
The father of the petitioner,
Abdul Hannan.
Abdul Hannan, who was working as the head teacher of (1111) number Kunamara LP School in the South Karimganj, in the Karimganj district. Died in harness on 16/6/1998, and on his death, the petitioner submitted an application for compassionate appointment on
3/12/2005.
3/12/2005. The grievance raised is that a said application was not placed before the DLC. Under the law, there is a requirement of an application for compassionate appointment to be placed before the DLC. And it is for the DLC to either accept or reject the application by providing reasons thereof. In view of such submission, the petition disposed of, directing the District Elementary Education Officer, Karimganj, to place the application petitioner for compassion before the next available legal Karimganj district. In the event the application was earlier placed, there would be no further requirement to place it again, and the petitioner would be informed about the outcome thereof.
Item 4.
My lord, this is also.
DLC page number,
My lord, it was also never placed.
same order. Give the name of the father, school, date of death, date of application, and same Karimganj.
Item 5.
Item 5, who is appearing? RC Saikya. Mr. Yes, Mr. Saikya. What is this matter about? What is the number of students in the school?
English.
Mr. Sharma,
Madam,
as per order of 13(9), you are required to provide what is the number of students in Milan Adabari LP School.
English.
Adjourn on the prayer of Mr. U. Sharma, Education, Elementary Education Department, for provide.
Secondary Education Department.
This is elementary. I don't.
This school has been amalgamated, therefore.
No, we have stayed it. We passed an interim order. We want the information, number of students in the ME school.
But the school is situated in same campus.
The instruction
Which
which
may be anywhere, but no amalgamation. কি করলো? John, for providing the information as regards the number of students in the Milan Adabari ME school. Based on so and so. Interim order to continue.
Items.
Interim order will continue.
Item 6.
Same thing.
6, same.
Same. School on Milan MEM Kasimpur school. His claim is max. Number of students in the ME should be less than 100. He says in his school there are 187 students. So we want the information whether it is right. If it is 187, you cannot amalgamate. And if it is less than 100, you tell us.
The instruction which we have received, they have invoked para 7.1.
No, they did not invoke anything.
For amalgamation, because as it is in the school in the same campus.
But still, 100 students has to be satisfied. Why is the amalgamation? Because one school is almost non-functional.
Yes.
Amalgamate with a functional school so that it can act as a whole.
Yes. Otherwise,
But if one school is functioning on its own in a very good manner, there is no requirement to amalgamate.
But if it is in the same campus, well,
That doesn't matter.
because
If it is same campus, does it mean that any number of the limit is not applicable.
That
We have to interpret that. We'll hear you. RM Chaudhary.
Item 7.
Yes, Mr. Chaudhary, what is the matter?
Your Lordship. This case is relating to scholarship of the petition.
Sorry.
Your Lordship will kindly peruse the order,
Pay scholarship.
my lord, merit scholarship.
Yes, what do you say, Mr. Kaushik? Pay scholarship of rupees.
My lord.
Under which scheme you are entitled for that scholarship?
My lord. Chief Minister's special scholarship examination, Your Lordship. As per certificate issued by the elementary education, Your Lordship will find
Mr. Kaushik, your confidence.
14 years.
Page 14, 1-4.
My lord. This is the admit card, Your Lordship. May I read it?
Department of Scholarship Examination.
My lord. Conducted by
Okay,
the
the-
elementary education.
The department conducts some scholarship examination.
It was under some scheme of Chief Minister's new scholarship
Huh.
examination scheme.
So he appeared and successful. So he claims that give me my money.
My lord.
I'll have to take it.
The Mr. B. Kaushik, counsel for the elementary education department, prays for an adjournment to provide the information as to whether the writ petitioner is entitled to a scholarship of rupees 7803. It's a one-time payment.
My lord. One time. Term
Hey.
deposit, my lord. That was deposited in the bank, Your Lordship, but that was still not received by the.
Okay, it was issued wrongly in incorrect account number.
My lord.
কি করলো? No, entitled as to in which account the scholarship which the petitioner is entitled amounting to rupees 7803 was paid, and whether that account is the account of the petitioner. He says it is deposited in somebody else's account.
SBI, but he
Yes,
ought to have
not his account.
Not
Look into it. List again. Did
Item 8.
BD last B Purokais. Then appears list again.
Item 9.
This matter list to
Authority
completion of the
Education
appointment.
Department to inform whether the application annexed is must made by the petitioner.
But after that,
Yes,
item 8.
compassionate. Was
Rejected
it
on the
placed-
ground of late submission of application, whereas the petitioner submitted his application in time, my lord, on 6/5/2010.
The same order to Maridio Divo. Place it before the thing. Because we gave you the opportunity to, we are not providing any information. Name of the father, school, date of death, date of application, we provide to the. By our earlier order of 29/2023, we required the education department to provide the information as to whether the application dated 6/5/2010 annexure C page 13 to the writ petitioner was made by the petitioner, and whether the seal and endorsement contained therein was of the concerned DEO, but when the matter is taken up today, no such information is made available. If not placed, informed.
Same order in earlier.
Sorry,
Same order.
same order.
Item 10.
Yes, Mr. Hussain. Compassionate appointment.
Yes, sir.
DLC.
Earlier record was called for.
My lord, here, my lord, I have received instruction, my lord. Regarding petition number, my lord, 6381/2017, my lord. Order dated 8/5/2019, my lord. Petitioner has not submitted the copy to the office along with the, my lord,
No,
along with
no,
the office of the
no.
aspect
Just
of-
a minute. Our order is inform the court as to the outcome of the application of petitioner made on 22/5/2012. What happened to that application? WPC 5543.
My lord.
Adjourned on the prayer of Mr. P. Saikia, learned counsel for the Deputy Commissioner Kamrup for providing the information as indicated in your order 22/9/2023. This commission.
Item 11.
Yes, Mr.
This is a challenge to the provincialization of the private respondent. On the last occasion, a lordship had called for the records.
District proposal. Yes, report of the DO.
My lord, the report is
Sorry.
not received.
The District Elementary Education Officer Kamrup Metro is directed to provide the information as indicated in the order of 22/9/2023 on the next returnable date, list on so and so interim order to continue.
Item 12.
Yes, Mr. Phogan.
The bone of contention is the leave from 2000.
What is that impugn order?
Yes, that's a page 107,
107.
119, annexure 17. That's the type copy. The relevant part is at page 122, the decision.
Whose order is this? Director?
Yes.
Director.
Secretary to the government of Assam.
Education Department.
Yes.
Who
Department of School
appears?
Education.
Education Department Secretary. You appear. Please come to page 119. Read the last 4 lines. Page 119.
Finding.
Huh?
Yes,
Please hurry up, Mr. Pegu. You can't take so much of time
Yes,
to
the
look at
director
it.
SCRT has forwarded
Who,
proposal.
no, just what do you mean by this? Who was requested to hand over charge of lecturer diet and allow her to discharge her service as lecturer? What does it mean? On one hand, hand over charge, and on the other hand, allow to discharge. What do you mean by that?
This is actually in terms of my representation. Yes.
Don't you think it's a self-conflicting statement?
Yes, because
You hand over charge and you also discharge the duty. How both can go hand in hand? If I hand over charge, I give it to you.
Yes.
If I discharge my duty, it is with me. Duita kene kya hoy? No, I have not read the order, but this line requested to hand over charge and allow to discharge duty. How both the events can take place simultaneously?
There may be some typographical error.
Something must be there.
The
Whatever it
original
is.
order is anyway next.
Same thing, requested a handover charge and allow her to discharge. Now what has happened?
It's at page 125.
Granting any leave and allowed to join again as lecturer. What, this person went to somewhere else?
In 2002, I was transferred. I took charge in 2003
Transferred to?
from Dibrugarh to
No,
Tinsukia.
originally, what is the,
DIT Azra as
no,
well.
no, originally, what is the appointment of this person? Original appointment?
The original appointment was in 1989, Your Lordships. I joined as the DIT Ajra.
No, no, in what post?
This is a lecturer.
Lecturer. Then
Lecturer.
what happened?
Then in 1989, 94, I was regularized.
Uh-huh.
Then I worked in 2002. 2002, I was transferred to Dibrugarh. I worked for
In the same post.
in the same post, but then in 2002, when the transfer happened, I was supposed to take charge in the district resource office as one of the lecturers, but I went and joined in 2003 in Tinsukia. That charge I took, but I was never, because in 2005, I went on leave after that. So 2003 to 2005, I took
We
handover
issue
in
notice
Tinsukia.
then. I think we have to issue notice in this
Yes.
matter.
That is the, I leave it to-
Actually, only notice.
yes.
Let me start giving notice. Responding a little. You are from?
I'm for SSA.
SSC. Aru Deputy Commissioner as in this cycle. Yes. 6 weeks, extra copy.
6 and 7.
3 days. Any private respondent? No.
No, Your Lordship, there's no private.
Item 13.
R. Begum, SB Chaudhary. Yes, ma'am. What is this? Compassionate appointment.
Yes,
DLC,
my lord, it was not placed.
not this, same order. Give the particulars.
Yes, my lord.
14.
Here, my lord, the
Same.
petitioner's mother had applied earlier, my lord, but she was rejected. Subsequently, she suffered from cancer, my lord, and the petitioner was minor. After attaining majority, he submitted his application on 2/3/2015, my lord. And his father died on 4/4/2015.
I think Khadim will be applicable.
Mother already applied.
No, mother applies, but
Our application
no, I
rejected.
think Khadim will
Rejected
be,
without showing any reason.
Khadim will be applicable, I think.
That part we have to verify Mother,
What do you want to verify?
regarding the applicability of that.
Sorry?
Because my lord,
No, what do you want to verify? If you want to verify something credible, we'll allow you. But what do you want to verify?
regarding the entitlement of the petitioner.
Entitlement.
My lord, because my
That
lord,
entitlement DLC will consider, not somebody else. Place it before the DLC.
my lord, that-
And where is the rejection by DLC?
Rejection, page 14, my lord.
Why did the
At the
DLC,
bottom, my lord.
why did the DLC reject?
Without any reason, showing any reason. The number is at
Biswas.
serial number 8, Meena Biswas.
Page number
At the
14.
bottom, page 14, 1/4.
14, Meena Biswas.
let's take an intervention for user.
Why did you reject it?
Recommended according to the High Court order, recommended size of the family, condition of the family. Recommended.
Mr. Saikya,
My lord,
suppose today I pass a order, so and so I appoint her in compassionate appointment. Will you like that order?
no, my lord,
I don't give any reason.
my lord.
Her Chaudhary, consider the writ petition, appoint the petitioner on compassionate appointment. If I pass this 4-line order, will you like it? Will you like it? The deputy commissioner Deputy Commissioner Karimganj to file an affidavit showing cause as to why a 4-line order should not be passed in this writ petition, directing the petitioner to be appointed on compassionate basis. You file your application. And whatever reason you give, we'll compare it with the reason of the TLC. List next week. See, if you, Deputy Commissioner, can pass any order without any reason, why the High Court cannot pass the same order? We'll also do away with the reason requirement of giving reason.
Next week.
Don't you think there is a necessity to give reasons?
Definitely, madam. They will reason, deputy commissioner have to be showed a reason, madam, why these candidates are.
See, only thing is financial comparison as per the judgment of the High Court. Where did you make that comparison? It's not your whim. That I like 3 persons, appoint them. I don't like the other 10%, reject them.
Perhaps we have to verify in regards of the one, my serial number was Sunit Ranjan Pal.
What will you verify? Just a minute. What will you verify?
On that, my lord, whether why his case has been, my lord.
How can you verify? How can you verify? Does the law allow you to verify and give a reason subsequently? Suppose the administrative order does not contain a reason. Will the law allow you to substitute a reason later on? No. Then how can you verify this? It's a futile exercise. Set aside, go back. Set aside the entire thing. Do whatever you do.
Regarding that, serial number 1, simply, my lord, recommended due to honorable court order. Perhaps, my lord, court is not directed to.
You show us which court order, where is the direction? Direction at the best will be place it and consider. High Court never issues order like the deputy commissioner. So let him show us. File the affidavit next week. The deputy commissioner to also state as to why recommendations were made for compassionate appointment without providing any reason, and at the same time others were rejected again without providing any reason. The deputy commissioner in one of the recommendation refers to an order of the court, and accordingly the deputy commissioner to also satisfy the court that there was a mandamus by the High Court to give appointment to a given candidate.
Perhaps serial number.
You file your affidavit.
2 and 3 maybe financial comparison are there, my lord. In 2 and 3, my lord.
The entire records of the DLC to be produced before the court. Yes, next item.
Item 15.
Yes, Mr. Pathak. What is this matter?
The petitioner has challenged the transfer order, Lordship.
Transfer.
Primarily on 3 grounds. Firstly, that it is vindictive. Secondly, she has some medical issues. But there is a very important legal issue also in the order. Your Lordship.
Where is the transfer order?
The transfer order is at page number 49. Your Lordship.
49. Was there some earlier transfer order and High Court order also?
No.
No, some orders are annexed.
No, earlier what had happened was the school had been amalgamated and there were some writ proceedings regarding the challenge to the amalgamation.
And that is so 49. Produce the petition submitted by head teacher. Requesting for arrangement of teachers. That's it. Where is the provision of law to put one teacher in another school and you will get your salary from the original school?
There is no such specific provision.
Is there any provision of law?
No specific provision, but this is just a stopgap arrangement done.
Even for stopgap, you need some authority somewhere. Suppose this school requires it. There is a provision for rationalization. Follow the law and do it. Why do you just pick up one man that from tomorrow you go to that school and for collecting your salary you come back?
These are administrative arrangement which is done immediately for immediate.
No, immediately.
Because rationalization, these are the process which takes time.
It doesn't take time. The way this one did not take time, that one also will not take time. All that you have to do is to find out which school has an excess teacher. Take out the junior most of the teacher of that one, transfer that man there.
He is the senior most.
Understand?
Here, your lordship will kindly see that's the last sentence.
We are staying it. We are staying it, but we give you liberty to do rationalization.
Yes.
Heard Mr. KP Pathak.
Otherwise, the students suffer because LP
So you do go for rationalization.
Your lordship will kindly appreciate one thing. LP school, there are 2 teachers only. So if this school doesn't have a teacher, the school will.
No, we are not on putting teacher in that school. We are on in what manner and whom we were putting to that school.
Lordship,
This
allow
is
me-
where we are
allow
finding
me to
little
take an
argument.
instruction, my lord. How far this school is, my lord? How far this school is, my lord?
Doesn't
If it is,
matter. We are staying it, you provide the information next day. Heard Mr. K.P. Pathak and counsel petitioner, also heard Mr. B. Kaushik and counsel for respondents in the elementary education department. The petitioner Gopa D, who is a teacher at 110. No.
110.
110 Model LP School, Lakhimpur. Lakhimpur in a Gorpara or Kachar. In the Kachar district. By the order impugned dated 14/9/2023 of the additional district commissioner in charge education Kachar had been allowed to discharge, had been directed to discharge her duties at 104 Tariniganj Model LP School, Lakhimpur. It is stated that the writ petitioner is the senior most of the teacher at 110 number Model LP School. From the impugned order, comma, it is discernible that the headmaster of 101 Tariniganj LP School had made an application stating that there are shortage of teacher in the school and therefore there is a requirement to place an appropriate teacher. Full stop. Even if the reason is good, the manner of requiring senior most teacher of another school to discharge her duties in some other school and again at the same time draw her salary from the original school appears to be arbitrary and unreasonable. We have been told that there is also a scheme of the government of Assam regarding rationalization of teachers, under which a school having excess teacher, in respect of a school having excess teacher, the junior most amongst the teacher is ordinarily transferred to a school having lesser number of teachers for the purpose of rationalization. In view of the above, the order dated 40 days shall remain stay until further orders. In the meantime, the respondents have the liberty to effect the rationalization process. If on facts, it is deemed that an additional teacher is required at 104 Tariniganj Model LP School. I got a notice 6 weeks.
or any means of arrangement. Or any means of arrangement.
Or
Because
any other means.
rationalization, my lord, it's a long process, my lord.
Don't take
My
away
humble
the
submission.
senior most teacher. The person will be aggrieved.
Because LP school, my lord, senior most doesn't play any role, my lord.
Doesn't matter. Everywhere seniority plays a role.
No, because there is no substantive post as head teacher.
Sorry.
There is no substantive post as head teacher in a LP school.
Doesn't matter. Doesn't matter.
So in that way,
doesn't matter.
The teacher will not be prejudiced.
Doesn't matter. When there is a scheme, invoke the scheme. Do it in a proper way.
Deeply obliged.
Item 16.
But this case is regarding the regular appointment of principal of Promotesh Burua College, Goripur. My lord, this is the third litigation.
He appears so.
My lord, in the first litigation.
I think in one of the litigation, there is a order of discord itself.
Yes, my lord.
When that
one person was left out.
That Guwahati University something APR score
Yes,
or
API
something
score.
like that.
Then my lord has given the direction.
So now what is the problem?
My lord has given the direction to include.
No, that's
him.
okay. Now what is the difficulty?
My lord, then the selection process as per that order, judgment and order, selection took place.
Yes, Abedi, now what is the legal issue? Response 6 has been appointed or selected.
Selected, my lord.
And you challenge the selection. On what ground?
My lord, what I'm saying, I'll take 1 minute. After that
first
judgment,
you tell us the ground.
The ground, there was a selection process which I challenged because of my
Mr. Abedin, before you hold my hand and say, just walk along with me, I also want to know where you are going to take me. If you say you are going to take me to Panbajar and you hold my hand, you take me towards Ganeshpuri, I am going to object to it. So I want the ground first.
I'll not.
On
take
what
that.
ground? No, on
Yes.
what ground first?
Ground, my lord, the earlier selection process where I stood first, they went for a fresh advertisement without saying anything about that selection. And I challenge
So
that.
in the earlier advertisement, you stood first.
I stood first.
That advertisement was abandoned.
Abandoned.
Then the new advertisement was issued.
I challenge that.
You challenged that new advertisement.
Yes.
In
During
which
that
writ petition?
during that pendency.
In which writ petition?
The writ petition number 5457 of 2022.
Is there any stay order in that?
No, there is no stay order.
List along with WPC. Also.
Page 108, there is an observation of the Honorable Court.
No, list along with the other writ petition.
It says that appointment is subject to outcome of petition. An appointment was done and person was also joined.
That's why list along with the
Lordship.
There are 3 writ petitions. May I give the number pending?
Everybody challenged the advertisement.
Yes.
Okay.
5457 of 2022.
Yeah. Write it in a piece of paper.
Item 17.
Take a convenient date. Item 17. Yes, A.K. Hussain. Yes, Mr. Hussain.
Before I go to the impugn order, my lord, earlier this honorable court's order, my lord, that
Impugn order dated so and so annexure 7.
before that, my lord, 51 is the as per High Court order, my lord, I have filed an appeal under section 14 of the Provincialization Act, my lord. And accordingly-
Mr. Hussain, can I take a look at the impugn orders?
Page 57 annexure 11.
Provincialization.
Yes, ma'am. DSC has not recommended his name, so it
Appeal
provincialization
under
is not considered.
My lord, I have been discharging as a starter.
Yes, ma'am. Petitioner is Sahidul. Sahidul appointed social science. Mr. Pegu,
Yes,
when your secretary takes a printout of the orders, the computer, does it not contain the option of giving more space between the lines? Who can read this kind of a order? There is hardly 1 millimeter gap between two different lines. Can't you print out your order with some a little bit of more space? See, when you try to read, the lines are simply vibrating there. You can't even focus on one line. for reading this kind of an order. What do you lose if you give a little bit more space between the lines? Ask them.
I'll
Heard Mr. A.K. Hussain and counsel for a petition also. The petitioner Sahidul Islam claims provincialization under the Act of 2017 as a social science teacher of the school. First off, the petitioner earlier instituted WBC 1490/2021, which was disposed of by the order dated 25/2022, requiring the petitioner to file an appeal under Section 14 of the Act of 2014 before the appellate authority. Accordingly, the order impugned dated 16/6/2023 had been passed. In para 4 of the said order, it had been recorded that the petitioner Sahidul Islam was appointed by the SMC of Paschim Moiradhoj MEM as assistant teacher on 5/1/2006, and he was allotted to teach us subject social science. In respect of Moiradhoj, Paschim Moiradhoj MEM, 4 teachers had been provincialized, namely Karima Khatun, Headmaster, Mahanandra Bora, science teacher, Alamuddin, assistant teacher, and Saleha Begum, assistant teacher. Full stop. Amongst the teachers who were provincialized, nothing had been indicated as to who had been provincialized as the social science teacher. Although Mahananda Bora appears to be the science teacher and Karima Khatun to be the headmaster. But between Alam Uddin and Salema Begum, no indication is given as to of which subject, no indication is given as to which subject the 2 teachers teaches in the school. But however, by the impugned order dated 16/6/2023, the claim for the petitioner had been rejected on the ground that the district scrutiny committee had not provided for provincialization of the petitioner, although no reason is available as to why the other 2 teachers were provincialized. Wherein, as per the order of the secretary to the government of Assam in the school education department, it is also an admitted position that under the Act of 2017, 1 teacher each, being of language, social science, and mathematics, can be provincialized. In view of the above, the order dated 16/6/2023, as well as the provincialization of Alamuddin and Salema Begum as teachers of Paschim Moiradhoj MEM is stayed until further orders. Have you made them party? Notice 6 weeks, extra copies 3 days.
In fact, they are language teacher.
I know. The respondents to produce the records regarding provincialization in the school, so as to enable the court to examine as to against which subject the aforesaid 2 teachers were provincialized.
Item 18.
Wait, please. The petitioner is aggrieved by cancellation of his PhD enrollment by the university
Case 30 is the impugn cancellation.
30.
30. Oh, my,
No, no, it
sorry.
cannot be
105.
Oh,
One,
sure.
an extra 30. What you find serial number 1 is the petitioner value. Reason for cancellation on the basis of recommendation of RSC and DRC due to unsatisfactory progress in research work. Now, my lord will kindly turn to the recommendation at page 107. Serial A is the petitioner value.
Not reported to him for the last 6 months, nor he came in with a compulsory as a full-time scholar. Saha requested that he be relieved of supervision of Jayanto Borua, as it is like a torture to him. The chair apprised the member since his psychological scholar never reported to him. Just what to do now?
My lord,
Reasons are very much against this one.
my lord, if your lordship finds page 77, 80, 82, 83, all are the application that was submitted by the petitioner and for allowing him to sit in the progress evaluation meeting. The first progress evaluation meeting was done. He was never being intimated.
Do one thing.
My lord.
Have you submitted something till now? Your progress to the university?
I have never been called in the progress evaluation meeting. The rule ordinance says that the supervisor has to notify the meeting on DRC and the RSC on 2020.
No, what do you of this one? That the scholar never reported to him for the last 6 months.
Absolutely a false statement.
Do one thing. Why don't you change the supervisor and give him somebody else?
But see, he has made them.
No, change the supervisor. Sometimes what happens, if there's an ego issue with the supervisor ensures that you'll never do it.
In fact, that is.
In fact, some of these situations have come to our knowledge.
But sometimes it's happened.
It happened. Change the supervisor, see his conduct for the next 3 months.
Yes.
Lordship may take up the matter tomorrow.
I'll
take
because there is equal possibility of this supervisor being little unscrupulous. Apart from the student being uncooperative, that possibility is also there.
That we cannot deny it.
So if it is, change the supervisor, give him chance of 3 months. We'll monitor his progress. If he does not do any work, we'll close his.
Take up day after tomorrow.
Day after tomorrow.
Okay. The
registrar
and
but a student should not be also deprived. Both are equally. We have to balance the two. And I have seen a lot of cases where a teacher, for some reason, does not like a student anymore. He also ensures that I'm going to ensure that your career never progresses in life.
That happens.
One instance we came up, one doctor, he had to wait for almost 12 years to get his MBBS degree. What is this?
Sometimes it happens.
If the man passes out every paper, only one subject he cannot pass out for 12 years, can you believe it?
But in one instance, actually my son was narrating me, when he was pursuing his MBBS, 2 students, they were quarrel with one of the teacher.
And teacher ensures that I'll see you at your.
They were not allowed
See,
to.
teachers, we have great respect for them because they teach. But if the teachers themselves involved in something else other than teaching, we have to look at them minus that element of that respect. They become like any other ordinary unscrupulous person. Normally, we have great respect for teachers. In fact, the other day, you must have noticed, teacher was sought to be recruited through a labor contractor. We heavily came down at that. Because teacher is somebody a little higher than everything else. But once that same person who is a teacher gets involved in unscrupulous acts, that element of that respect has to be removed and that man has to be looked at from that point of view.
Ultimately, the society has come to that.
What to do?
That is a big problem.
Someday he must have asked something from this student. He did not give or did not.
Let's say I'll talk to the registrar tomorrow. Let's say maybe 6 or 7.
They tell him we like the supervisor to be changed for 3 months.
And supervisor himself requested that he should be relieved. One of the documents. I'll talk to the
So
registrar.
change the supervisor, see his progress. If he does not do anything, tell us.
I'll talk to the
Basically, the supervisor who
It at times happens. They are not, supervisors are not above board all the time. Especially these sensitive matters.
In fact, the
Where almost everything depends on the supervisor.
It's in PhD course, it is depend upon that.
See, supervisor is like a guru. Student is like a shishya. That guru-shishya relation is a two-way relation. It's not only a one-way relation.
But see, nowadays, everything has been.
So, if the guru forgoes his duties and responsibilities, he has to be shifted out of the concept of being a guru, and we have to look at something.
That approach is missing now.
No, what to do? The society.
Because the student also became.
Both. I'm not saying only one aspect.
But see, I'll take instruction. I'll talk to the registrar today itself. And let's see if they have.
Adjourn on the prayer, Mr. STKL, and come to Assam University. We're not putting anything because otherwise our one word may carry a lot of. Day after tomorrow. Day after tomorrow. Day after tomorrow.
Item 19.
So, Mr. Mongol.
This petitioners people lordship are Sikya Kurmi, Songjogi Sikya community volunteers. They serve for particular period, 2 years, 3 years, 4 years, 5 years, like that, under the SSA.
So we issue notice.
Identical person has approached this honorable court, and this honorable court was pleased to dispose of the matter. That means they responded to consider their case.
Where is that order?
Lordship, at page 164.
My order.
No, my lord, other court, my lord Justice Jamil. Page 164. And my lord, operative order, my lord, page 249. Is 248, my lord, the order portion, my lord.
249.
248, my lord.
248. This minister one, Amarat order. I think I also passed one order. Application to minister, give it to the secretary. I think that's the only purpose. This time, the petitioners who are all Shiksha Karmis,
yes,
under the SSA, are agreed by the discontinuance of their service. Some similarly situated persons earlier had made an application to the Minister of Education to the Government of Assam for redressal of their grievance. When the grievance was not adequately addressed, they approached this court by way of writ petition. Wherein there is an order dated 23/6/2023. What is the writ petition number?
Petition number
3667/2023. কি বলো? Requiring the petitioners therein to file applications before the Secretary to the Government of Assam in the School Education Department. Petitioner prays for a similar order, prayer granted. The petitioner is also allowed to file application before the Secretary Education Department. And upon the same being filed, the Secretary may pass any reasoned order on the same as may be advised.
In our case, page 250, we have filed already before the Secretary.
It stated that an application dated so-and-so had already been filed. If it is so, the said application may be given its in if it is so, no further application required to be submitted, and the secretary may pass the written order on the application indicated.
Developers.
Item 20.
20. Yes, Mr. Bhuya.
My lord. May I please as a lordship? My lord, the petitioner service was provincialized under the 2011 Act, my lord.
Subject teacher, logic and philosophy. It's already provincialized.
My lord,
at the time.
We issued notice.
my lord,
Here
notice
we are notice
notice,
66. Elementary Education Department.
Secondary.
secondary.
U. Sharma, Secondary Education Department. Mr. P. Sakia, Deputy Commissioner, Bongaigaon. Notice upon 4 and 7 registered post 3 days.
21.
Compassionate. DLC.
Here, my lord, it was rejected by DLC. Page 21, page 39, my lord,
39.
on the ground of late submission of application. 39.
Who is the petitioner?
Iftikhar Ahmed
Iftikhar
Khan,
Ahmed.
my lord.
The Deputy Commissioner Karimganj to show cause as to why the application petitioner for compassionate appointment had again been rejected for late submission in a circumstance where the said ground had been rejected by the court in its order dated 10/4/2015 in WBC 1351/2015, wherein in spite of there being a late submission, there is a requirement to place it before the DLC to consider it on its own merit. Deputy Commissioner to also show cause as to why contempt proceedings should not be drawn up against him.
Item 22.
Ask him. Ask him, we want to draw up a contempt on this Deputy Commissioner. See, late submission, it was your ground once. It was rejected by the High Court. Say, place it on, take care on merit. Why will you again reject it on late ground?
Those no. That means they have not given the weightage of the High Court of Appeal.
Ask him. The Deputy Commissioner remain personally present. Let it come. Or not required. Personal file your affidavit and tell him we want to intend to drop a contempt against him. Yes, Mr. Bhuya.
Please, my lord, matter pertains to professional
DLC page number.
not place before it.
Not place.
Not place.
Order mari dibo. Date of death, name of the father, where he worked, date of application.
Highly obliged. Likhi dibo.
23.
Yes, Mr. Ali.
That is lost.
Provincialization.
No, regarding shifting, my lord, after erosion, my
Constitutional
lord,
School Managing Committee.
school has been, my lord, eroded, my lord, and then school managing committee along with public, my lord, decided to shift, my lord, to nearby place, and it was forwarded to the district authority, my lord, for
Shifting of the school because of erosion.
erosion.
Then
Thereafter, my lord, proposal was sent to district commissioner, my lord, and he approved. DO pass order, my lord, case 25.
rejecting it.
No, my lord. He has also, my lord.
He also approved.
Lord.
Now, what
But
is
the
the grievance?
BO is not acting, my lord. He is, my lord.
Directing that to take. Yes, Madam Fukan.
He
Your
wanted to-
district elementary education officer had passed an order of 49/2023. The block elementary education is not obeying that order. Right.
He is trying to, my lord, establish in another place.
Why is he not following the superiors? The block elementary education officer Borkhetri to show cause as to why the order of the superior authority dated 14/9/2023 being the block elementary education officer Nalwa East is not being followed. The block elementary education officer to remain personally represented before the court on the next reasonable date, list and so and so. See, everybody approves. The higher authority says do it. Why the blockman is not doing it? Let him come. Yes. Yes,
petitioners here in your lordship are the TET qualified candidate. Your lordship. They are aggrieved by the recruitment of 11,319.
Quashing the appointments of one number of candidates supposed to under the state.
Similar petitions are pending, your lordship, before this honorable court, your lordship.
But why should we quash 11,000 appointments at the instance of one writ petitioner?
Actually, your lordship, the ground that on the without issuing the advertisement, your lordship, this engagement has been done.
Without issuing advertisement. The petitioner assails the appointment of 11,319 number of assistant teachers under the strengthening elementary education of Assam under the scheme of centering in as indicated in the notification 6/9/2017 on the ground that no advertisement was issued. The respondents to provide the information as to what procedure was followed for such appointments based on so and so.
May I take this matter along with the petition?
No.
Similar?
It doesn't matter. We'll decide it. Others can follow this one.
25.
There is no necessity that this one has to follow the other one. Other one can also follow this. Let us examine why it was done. Madam Fukan, take note of this order. The records pertaining to the procedure adopted be produced before the court. Yes, Nazir Hussain. Compassionate. DLC page number.
Relevant page 34, lordship.
34.
And vacancy position page 30, lordship. Page 34, serial number.
Where is the
9.
rejection? 34, serial number 9, Jafar Iqbal.
Yes, lordship. There is no
We are
reason
issuing
mentioned.
notice. There is some financial comparison. And notice 66 extra copies 3D. Any private respondent?
No, lordship. Lordship, there is no mentioned in the financial position, lordship. In the
No, therefore will
Yes,
the
lordship.
respondents to produce the records of the DLC.
Lordship.
Item 26.
6,
May I
yes,
please, your lordship? This writ petition is filed by the petitioner against the disengagement letter dated, my lord.
So what is to why the discharge should not be quashed? Where is the discharge order, madam?
My lord, discharge letter is discharge letter in annexure 5, my lord, in page number 2425, my lord.
24.
Yeah, 2425, my lord.
Where is the appointment letter?
My lord, the appointment letter is annexure 1 in page number 12, my lord. Appointed on 8/9/2001, my lord, by the respondent number 2 and 3, my lord.
The petitioner was appointed as a grade 4 as per the communication dated 12/9/2001 of the Secretary Paschim Kamrup Junior College, Honiadi, in the Kamrup district. And by the discharge letter dated 15/1/2023, he was discharged from service as per the resolution of the governing body dated 12/1/2003. The resolution of the governing body be placed before the court till the next returnable date. The discharge letter dated 13/8/2022 shall remain state. Notice 6 returnable on so and so. Extra copies 3 days. Steps on. My Mr. Sharma for respondent number 1.
Yes, ma'am.
2 and 3 steps registered post 3 days.
27.
7 years.
Petitioner,
17 November.
a student of LLB, Korimgos Law College.
Hmm.
He got admission in 2020.
Is a student, law student.
Law student.
What happened to him?
After his
Directly
admission,
have to activate the profile ID and then also allowed to appear in the 5th examination. In which college?
Korimgos Law College.
Who appears for Karimganj College? You appear for?
Assam University.
I say this college is under the Assam University.
My lord.
Just inquire from the college why they are not allowing him.
Lordship,
Any reason discernible from the petition?
Lordship, nothing has been disclosed by the petitioner. Lordship, after going through the petition, it transpires that there is some dispute with regard to his qualification. Probably that's why his
Qualification?
yes, Lordship.
Which qualification? That BA?
Lordship, he submitted.
He's doing LLB, must be a BA or BSc something.
Lordship is
He has completed.
From which page?
Lordship, page 33. Lordship.
33.
That was this qualification was acquired by him under the Director of Madras Education Secretary.
This is dated your matriculation is from madrasa.
Madrasa, my lord.
Where is your matric? Let us see your certificate.
This page number 16, my lord.
16, I think.
16 is FM, my lord. FM is equivalent to base rate, my lord. And page number 14, that is the.
Is the petitioner a graduate?
My lord.
Is he a graduate?
My lord. As per this notification, the page number 33. This is the Deputy Director of Madrasa Education Secretary Assam Kailipara issued notification.
No. By what authority the deputy director has to declare?
That's probably my learned friend.
Yes, Madrasa Board. So your qualification is metric also madrasa.
Madrasa.
Graduation is also madrasa.
Post-graduation also madrasa.
Postgraduate madrasa. So question they are raising possibly whether you are entitled to do a LLB course or not.
Yes, ma'am.
Possibly that is the issue.
It may be low.
What is the required qualification for LLB?
LLB Lordship for 5 years, high secondary for 3 years, bachelor degree in any
No,
stream.
do we have anything? Yes, what is the qualification to join a LLB course?
For 3 years.
No. First tell me will you allow this man to join the medical course? Suppose this person would have applied for the first year MBBS, would he have been qualified?
I think no.
I think this requires some examination because it will have a lot of implication upon many people. Because equivalence may be for the purpose of
According to degree level.
that he will be recognized to be a graduate.
For service purpose, that may be.
For other purposes, but to join a professional course, whether it is, yes, Mr. Ameshek, any idea? Because professional courses are something totally different.
Yes, my learned friend may produce this guideline, my lord, of the university for admission, qualification for admission in the LLB course.
For LLB
Because,
notice, it is clear. I am aware. For 3 years course, he must be bachelor degree in any of the stream. For 5 years course.
So, but this Deputy Direction Madrasa declares an equivalence of Madrasa FM to be BA examination. So, by virtue of this equivalence, does he become eligible for LLB course? I think that is the question.
I have doubts.
So, similarly, we are putting a question. He is also Madrasa intermediate pass. Will this man be qualified for first year MBBS? Or will he be qualified for going into engineering?
Professional course, lordship, I think.
I think we'll have to decide this issue.
What's the issue notice?
But notice will take a long time because you're a student. If he's should be allowed, you should do it in a.
After due verification, university has provided the.
No. Somehow, if you get into something, that doesn't mean your everything is settled. Somehow, if you manage to get into a room, that doesn't mean you are entitled to be in the room. Who is entitled to come into this room and argue? One lawyer under the bar council registered. Suppose one man just manages to get into the room, are we bound to hear him as a lawyer? No. It's a serious thing. The petitioner has the qualification of Assam Madrasa FM final examination of 2013 under the State Madrasa Education Board Assam, and also relies upon a notification issued by the Deputy Director of Madrasa Education and Secretary State Madrasa Board Assam, by which the Madrasa final FM examination had been declared to be equivalent to BA examination. Based upon the said qualification, the petitioner took admission to the LLB course under the respondent Assam University by being a student of what school? College? Karimganj Law College. The college authorities are not allowing the petitioner to further pursue the LLB course as the authorities are unable to accept that the petitioner is duly qualified to be admitted to the eligibility course by virtue of his qualification of Madrasa Final FM examination. The respondents in the Assam University to respond to the aforesaid question as to what is the required qualification to be eligible for a LLB course. That is, whether it should be the graduation degree simpliciter from a university, recognized university, or any equivalence of a graduation in any discipline would also be a qualification, the required qualification to be eligible for a LLB course. The same question be also answered by the authorities in the higher education department of the government of Assam by expressing their views along with supporting materials. List on so and so.
Extra copy.
Extra copies to both the land council.
Much.
28.
Notice কৰি থব বাইরে issue notice return also তেতিয়াহলে এই steps কেটাও দি দিও Mr. Council we are issuing notice take steps extra copies and all to all of us not placed a compassionate not placed give the particulars compassionate not placed maybe place it before the next study or if already placed inform the petitioner and name of the father, where he was working, date of death, date of application. 30, 31.
Orders stay vacating 30 and 31.
That is a lordship. Lordship, order is at page $16. Lordship.
No, who appears for I
I am
2771?
I am appearing for the IA lordship.
You want a vacation of the interim order. Where is the interim order? Page number in the IA?
Page number 16 lordship.
16.
So,
Why should it be vacated?
lordship, she claims claim provincialization on the basis of lordship seniority. Seniority is not a criteria. And secondly, lordship,
Then what is the criteria?
criteria is only on 3 subjects, lordship. The provincialization shall be made on the social
What
studies.
subject the petitioner teaches?
Petitioner is a science teacher, lordship. This is the case, lordship. Petitioner is
I
a
know.
science teacher.
Which document will show petitioner is a science teacher?
Appointment order, lordship, at page 18.
Number? Page number?
Page number 18, lordship.
18. Science teacher. So this is Bhupen Dihinia, science teacher. And the petitioner?
Petitioner is an arts teacher, lordship.
Where is the appointment order?
Her appointment order is not annexed in your lordship. In her petition, maybe it is the next. 1483, lordship.
Page number? This is what kind of school? ME school? ME school. Where is the appointment of the petitioner?
Page 14, lordship.
Page
Or
14.
in the right petition.
In the document petition number 1483/2020.
What is the qualification of Umeshwari Dole?
Is BA, my lord?
BA.
Yes. It's admitted, my lord, is arts.
So we vacate this one because science has an independent right.
Yes.
And the other one we retain.
Yes.
I think in respect of 8 and 9 both are stayed.
Yes, lordship.
Dunnokanto course, that's why we are not vacating. Bhupen Dihinga, let us vacate it. Heard MSR Devi, Land Counsel for the applicant, also heard Mr. J. Paying, Land Counsel for the writ petitioner, as well as Mr. B. Kaushik, Land Counsel for the Elementary Education Department of the Government of Assam. The writ petitioner, Umeshwari Doloi, had sailed the provincialization of Durnokanto course and Bhupen Dihingia on the ground that, as per the order of appointment, the writ petitioner is senior to both the teachers. Bhupen Dihingia has instituted this interlocutory application for vacating the interim order dated 28/2/2020, by which the provincialization of Durnokanto course and Bhupen Dihingia were stayed on the ground that Bhupen Dihingia is a science teacher in the school, and to substantiate that, the order of appointment dated appointment available as Annexure B, page 18 to the interlocutory application is referred. Mr. J. Payeng, Land Counsel for the writ petitioner Umeswari Doloi, fairly states that Umeswari Doloi is an arts teacher in the school having the qualification BA and is not the science teacher. Section 311, 311. Section 311 of the Act of 3111 of the 111 of the Act of 2017 provides that one teacher each in the subjects of language, social science, and science and mathematics would be provincialized. As the respective claims for provincialization of the writ petitioner Umeswari Doloi and the applicant Bhupen Dihingia, last sentence too, are based upon, are not interconnected with each other, where Bhupen Dihingia has an independent legal right to be provincialized as a science teacher, whereas Umeswari Doloi may claim the legal right to be provincialized as a teacher in subject, language, or social science. We are of the view that the interim order dated 28/2/2020 in respect of the applicant Bhupen Dihingia is required to be modified. Accordingly, it stands modified, and the interim order shall now be applicable only in respect of the respondent Durnokanto course, and shall not be applicable in respect of applicant Bhupen Dihingia. Consequences of the modification interim order be made applicable to the applicant Bhupen Dihingia. I allowed as indicated above. Is partially modified.
32.
What is this? Mr.
This is a petition application, my lord.
No, I is for what purpose?
Page 7. Yes.
Cancel or modify the ex parte interim order. Where is the interim order?
My lord, page 71, 72. Last page is the operative.
71. Where is the order dated 28/6/2023?
My lord, page 66.
66. Now, who will be the headmaster of the amalgamated school? That is the issue.
My lord, I would like to draw my lord's attention to page 64.
Yes, Mr. Purokasto, what is your reason to assume this order?
My lord, Roshi, can you see the?
Senior.
My lord.
You were appointed in 1993.
My lord, yes, my lord.
Then,
I was appointed on regular basis, my lord, subject to my basic training. Therefore, my appointment is a regular appointment, and he was initially, my lord, at Bhanjar teacher, honorary teacher. Subsequently, he was provincialized in 19.
no, first tell me, who can be the headmaster of a ME school?
After amalgamation. After amalgamation, my lord, as part the, my lord.
No, but the reason.
Reason given, my lord, he is getting, my lord, higher get pay.
That's
I am getting, my lord, lower get pay.
Yes, Mr. Kaushik, where is Mr. B. Kaushik? This is by BTC or what? This order?
BTC.
Where is Mr. Bora? Ask him to come.
My lord, the aspect is cleared otherwise in page 64.
We have read it. So issue is whether with a trained graduate teacher having a higher scale of pay, irrespective of his date of appointment, has precedence over the teacher of the LP section.
LP section,
who is having a lower scale. That is the only issue.
That is the only issue.
My lord, another thing is there.
We'll hear them on what basis they say.
My lord, another thing is
basically, my lord, as it appears from the, my lord, impugn order, they are saying that he is getting higher grade pay and I am getting lower grade pay. Therefore, he is senior. On the other hand, my lord, as per the amalgamation policy, my lord, after amalgamation, all the staff of the LP school shall be deemed to be the staff of the ME school.
They may be, but a person having a higher pay is normally understood to be above the person getting a lower pay. Normally, so we'll hear Mr. Bora.
Other day, my lord, has put the question.
Both are teachers of the ME school. Question is, who will be the headmaster? BTC authority says that the ME school teacher gets a higher scale pay. So he should be the headmaster. That is challenged by Mr. Purokaste's client. He is the LP school teacher. There is a stay order. Now, what is the, after amalgamation, what happens to the LP school teacher? They are at par with the ME school, or that distinction is always maintained?
So the 2021 notification of the amalgamation.
What does it provide?
Distinction is always maintained. On last occasion, your lordship asked for this notification.
I heard this earlier.
Yes, yes. Well, this is the first set of column is for ME school, and next is the amalgamated LP school.
I have
52. I have 52.
So there is a difference in the grade pay.
Yes, ma'am.
And both are trained graduate teachers.
Yes, ma'am.
No, scale they are getting lower. But as per your amalgamation scheme, what happens to this LP school teacher? That distinction, please, one by one. What happens is the distinction between a LP and ME teacher is maintained even after amalgamation?
Specifically, though, that distinction has not
No,
been said.
if you say yes, we're going to ask you one more aspect. This LP school teacher, he will also be a headmaster at one point of time. He has a right.
Yeah.
Now, had this school not been amalgamated, this man would have been a headmaster of the LP school. just because the school is amalgamated, the identity of the LP school now is no more. Everything becomes the ME school. Will his, by virtue of amalgamation, will his right to be the headmaster be not taken away?
That
Because same thing, when it becomes amalgamation is between ME and high school, we have noticed that there is some, at least some provision. The headmaster of the ME school will become the assistant headmaster. At least something is given to him. And in respect of amalgamation with higher secondary, we found that the ME school teacher, yesterday, I think Madam Saikia's case, this same thing happened. He can become the vice principal. And after becoming vice principal for 5 years, he can also become a principal. So everywhere, this avenue at least is retained. What about the amalgamation between LP and ME? Does something remains for the LP man, or the LP man is wholly ousted?
The headmaster of the LP school, as the post of headmaster in a LP school is not a substantive post, he gets a additional charge along with his salary, 300 rupees. And
whatever it is,
that he continues.
Mr. Kaushik, at least that man has a status.
Yes.
In whatever manner you may give, either 300 rupees
and
more or in charge or whatever it is.
And he continues that.
The man has the pride of being the headmaster of the school. That is something a man.
Designation may not be there, but the financial benefit which was given to him as a head teacher, that continues.
Hey, everybody knows him to be the headmaster, Mr. Kaushik. Don't tell me that. At least the public knows him.
Yes,
we don't know about the government. Everybody knows him. He's the headmaster. And in the village, the headmaster has a great respect also. Other day, I came across a man. He very proudly says, "Now I have become the headmaster." It's a
that's true.
Self-induced feeling that that man has. So don't tell me that there is no headmaster. Now, what provision is left for the LP schools teachers?
Your Lordship will
after
kindly
amalgamation?
find page 87. The office memorandum.
You do one thing. You come prepared. Tell us the whole thing. I don't think we can conclude today.
Yes.
When do you want? Because BTC, I think basically they are following you.
Yes.
It's not your any independent decision. They are following what the Government of Education Department is requiring to do. What further provision remains in respect of the teacher of the LP school? Otherwise, tomorrow this will be a good ground to challenge the amalgamation. A teacher will come and say, "I will forever lose my right to ever be a headmaster, so you cannot amalgamate." If I remain independent, at one point of time, I will become. We have something for them. Otherwise, admittedly, Mr. Porga's client is having a little lower grade pay. Mr. Avedin's client is having a little higher grade pay. His client is appointed prior. I think seniority-wise, your man is more senior.
No.
Take up with the authorities.
Mr. Lordship permits one point, my lord. For ME school headmaster, you need 10 years experience. Like yesterday, your Lordship came across that 17 years and 15 years. Over here, there is a notification. You need 10 years of experience to become a headmaster. But after amalgamation, they are born in the cadre only after amalgamation in the year 2018.
So, under which provision of law the previous service can be washed away? You cannot just wash away a previous 10 years of service of almost how many years, I don't know. Can there be any service law jurisprudence principle whereby a particular tenure of service of a man be simply obliterated? You cannot. Some relevance has to be given to that also. We are only asking what relevance they are giving. If there is nothing, we'll direct you to give something. If the existing framework does not provide for something, I think it will be a fit case to direct the secretary to look into this aspect and provide for something. Otherwise, we can never decide this dispute. Mr. Abedin will say salary, Mr. Porokas will say My total 10-year service is more. And it's like two parallel lines. It will never meet.
Because the office memorandum that is holding the field for promotion, it says simply 10 years. 10 years experience.
Experience as?
That is not there.
Then why will you discard his experience then?
Here in the amalgamation notification, Roman 6, it says like this.
What does it say?
In case one or more LP school or one or more ME schools are amalgamated, the assistant
No,
teacher,
but this is between amalgamation LP and LP, ME and ME.
LP and ME.
LP and ME also.
Yes.
What does it provide?
In case one or more LP school and one or more ME schools are amalgamated, the assistant teachers of LP school shall be the employee of the amalgamated school, and the headmaster of the ME school shall be the headmaster of the amalgamated school. The staff pattern shall be fixed as per the existing norms for a ME school, and the excess teaching employee shall be posted elsewhere against any vacant post with their
So that is
seniority.
again a rationalization. It is something different.
There shall not be any financial loss, and whatever emolument they are getting shall continue. The head teacher of LP school shall continue to draw charge allowance till his retirement or till his posting elsewhere.
So that is provided. What, because LP school does not have the post of headmaster.
Substantive post of
So you will continue to get the.
Yes.
But this man is, Mr. Poroquester's client will not be satisfied with this much. He says, I'm a teacher of the LP school. After amalgamation, I am also a teacher of the amalgamated LP school. Why will I be completely ousted from being considered for headmaster of the ME school? This is post-amalgamation, not at the time of amalgamation. The reply you have read out is to answer what will happen at the time of amalgamation.
No, post-amalgamation.
Mr. Purokasta, please. You should not interrupt somebody else when somebody is speaking. Yes, sir.
It is also post-amalgamation situation has been taken care of. The headmaster who was an LP school headmaster, after amalgamation, he can't
this
be an
situation has not been taken care of. Maybe in certain respect it is also post, but not in this respect.
Yes,
this answer is not there.
Probably not in that situation.
So we best we ask your secretary to take a decision.
But the office memorandum that is which says, it is not that the LP school teacher after amalgamation will lose the right of promotion. After 10 years of service, he gets the right of promotion.
Yes.
But the
no,
that
he has the right. But there will be one ME school teacher who will be getting a little higher scale of pay. So there is again another service law jurisprudence principle that the man getting a higher pay is one level above the man getting a lower pay. So he will be affected by that. How do you take care of that aspect? I think it's silent. You cannot read anything from there.
That this 2010
list again also, so we'll hear you. Most likely we'll send it to the secretary to take a decision. 16, no, sorry, too close to the vacation. Before. After vacation, no?
Immediately after.
But who has filed the application for vacation? He will be affected. Mr. Abedin may not like it.
I leave it to your lordship, but I will not like it, my lord.
Definitely.
Nobody is affected because he was not appointed. My lord, block element election was allowed to hold it.
No,
that is not the answer. So let him operate. We'll decide this issue. Let him be the headmaster. Why you are getting only a statistic pleasure out of depriving this man? You are not gaining anything by it. Okay, that is okay. Nine to go.
Article 9 approval. Any other day other than 9 months, that particular day I will not do.
Pick up with the court.
11th, I will not do it. Immediate.
Then we vacate the interim order. We find good reason within the existing material that a man with a higher scale under the general provisions of service law is a level higher than the man getting a lower scale. It's always. A man getting a lower scale cannot be heading the institute and having control over the man having a higher skill. On that principle, we'll vacate the interim order. If you don't agree on a date. If you agree on a date, we'll hear it finally. Sorry, Mr. Purakaster, we can't waste judicial time for fixing a date. Let's go to the other matter. You take whatever is convenient. If it is long date, we are vacating the interim order. If it's a short date, we'll hear you. Next item, please.
Item 34 for admission.
Just 34. Who appears? 34. 34, yes, sir. What is this matter?
My lord, I appeared for a selection process.
12 তারিখে বলে প্রোগ্রেসটা না থাকে বলে গোটেকেটা মাতি আনি খুলো if they don't agree on a short date we'll take it up once again. We'll take up the application for vacating the interim order on its own merit as it exists today. Mr. Kaushik, if the learned council cannot arrive at a very, very short date, we are going to take up the IA on its own merit on the materials as it exists as on today in course of the day itself. Or else you agree to a short date. You means I mean everybody. If you cannot agree, then we'll take it up on its merit on whatever material law as it exists as on today. Definitely, and there is nothing wrong. So either short date or we'll take it up. Yes, what is this matter?
My lord, over here in this case, I appeared for a selection process for assistant professor. I'm working in a high school. And my lord, during the process of the selection, I was not given 2 marks in one column, that is page 82, my lord. So your lordship, in this case,
No, today what we do?
only thing that your
Mr.
lordship,
Avedin, are you hearing the matter today?
no, my lord.
Then why you waste time?
No, your lordship may remand the matter to the director to examine whether I am
Remand is not
entitled.
asking. They have to agree because they are holding a right in their favor.
No, nobody else is selected over here. So that is the.
Achha, no one is selected. Then for whom do you appear?
College.
Lordship,
For whom
I'm
do you
under
appear?
3, 4, 5, 6 Lordship. Respondent
Who are they?
Lordship,
College.
principal and governing body secretary, president Lordship. The post was already.
Then if we remand back to whom?
Director of Elementary, Director of Higher Education to find out whether I'm entitled to 2 marks. If I'm entitled to 2 marks, then I get in.
But will the director not be asserting the power of the selection committee if I issue that direction?
Yes, my lord.
Then that will be again another infirmity. Law requires selection committee to do it, and I'll direct the director to do it. And again, director will approve his own order later on.
Director will place them before the selection committee. It will become shorter, my lord. Only question if I'm entitled to 2 marks. If I'm entitled, I mean.
Which page?
My lord, page 82.
82. What's the name of this man? Ahmaduddin. Ahmaduddin. Where do you want 2 marks?
My lord, this is a publication in ISSN and ISBN Journal 2.
Serial, the column number?
My column number 1, 2, 3, 4, 5, 6, 7, 8, 9. It's 10th, my lord.
Which one is 10? You have to start counting it now.
My lord, over there, after MPhil.
Publication in ISSBN, ISBN Journal.
Yes, my lord.
You are given no marks.
No marks.
And who is given, and who was the first candidate? Kobita Gogoi.
Yes, my lord.
Who appears for Kobita Gogoi?
She did not join, my lord.
Huh?
She did not join because in the meantime she joined in Haju. So post is vacant, lordship. So if I get that 2 marks, I score over Gogoi also.
Why do you need 2 marks? If Gogoi is not there, You can do it till 61 marks itself.
But on that, they're saying it's a single post, single selection, so they cannot go beyond.
No, there will be one more. Junub Audel is also there.
No, that's below me.
Two people are selected.
Yes.
You'll be the number one now.
Yes, madam.
If Kavita goes.
Yes, madam.
Then why should he interfere in all these things?
That is my prayer is also there.
If the selected candidate doesn't join, madam, there is no provision for making a waiting list candidate.
No, you are yet to select. Don't select that man.
Let's see.
By virtue of joining another post, possibly that candidate had become ineligible to further continue with this selection. The day the candidate joined another equivalent post elsewhere, don't you think the candidate became ineligible from that point onwards to cancel our candidature?
But the candidate has already been selected by the selection committee.
Okay, now, but it is yet to be completed. You cancel our candidature. Why will you render one selection futile knowingly? You know that I'll select a man, I know he'll not join also.
She refused to join.
So moment she refused to join, her candidature itself is disqualified. So you will now make the selection amongst the remaining candidates. Where is the law? Practice is not the one. Where is the law? The respondents in the Director of Higher Education, the sum to provide the relevant law by which a candidate who had expressed unwillingness to further continue in the selection process will be compelled to remain in the selection process, evaluate that candidate, declare the candidate to be the first selected candidate, and as the candidate will not join, thereafter cancel the entire selection process. The directive to provide the relevant provision of law which supports such an action.
I never.
Give it to this man. If the other one is. In other words, whether upon expressing the unwillingness to continue in a selection process, the candidature of a candidate remains in the fray or it stands automatically cancelled at that relevant point of time when the unwillingness is expressed.
35 and
It will be
36.
better for you. If number one goes, it's better for you. We will direct them to complete it.
This one. November.
So Sheikh, you are here.
I am
number.
referring to order dated 15/9/2023.
PK Bora standing counsel submit due to inadvertence direction issue. What is that thing? Order dated 12/5, court order.
Yes, my lord.
12/5, paragraph 8.
Last chance given, etc.
Yes, who appears for Deputy Commissioner Dhubri and Director of Elementary Education also? You respond to para 8 of the order dated
My lord. My lord, we have
12/5/2023.
my lord, we have got the original copy of the district scrutiny
No,
committee.
we don't know. You respond to this order.
My lord.
Have you read the para 8? Please read it. You have the audio with you?
No,
It will
my
be
lord,
you.
order is not available, but, 2500.
What Mr. Pegu and Mr. Saikia? We don't want all those. Read paragraph 8 and then respond to it. It's a serious allegation. Under RTI, you give a different document to a man, which does not exist in record. You have to explain that first.
My lord, that original, my lord, district scrutiny committee report, which is sent to the director.
The court has framed one question that under the RTI, a document was given to the petitioner, which is not a part of the record. We want to hear only on that issue for the time being.
That part, my lord, the concerned department may clear, because my lord, that is RTI concerned department.
Who had given the RTI document? Director or deputy commissioner?
District Elementary Education.
He had given a different document. The district elementary education officer of which district? Dhubri, to remain personally present in the court on the next returnable date to explain the circumstance as reflected in para 8 of the order dated
12/5.
12/5/2023, wherein it is recorded that under the RTI, a document was given to the petitioner which does not find place in the record. List on so and so.
My lord, not to the petitioner,
To the?
but to the respondent.
Respondent.
My lord, another thing, my lord, by order dated 15/9.
And petitioner name is recommended for
No, we have yet to go to the merit of the case. We'll
My
hear.
lord, another thing, my lord, your lordship, 15/9/23, director is to produce the record. If he does not produce, then your
Okay,
lordship.
next that we'll see to it.
My lord.
First, let us sort out why under RTI a document was given which is not there on record. This is a serious allegation, Mr.
Yes.
And that may have a bearing either way. Yes.
My lord, RTI
Next item.
Information provided by the office of the director, my lord, not by the DO.
Then let the director remain present. DO needs to director likha. Bolo, next item to diyo. Enough of time for this. DO bodli director kori diyo. Director remain present.
37.
37. Yes, who is appealing? SB law score. What is this?
May I please, your lordship? Lordship, kindly pass about adjourn.
On the prayer of madam, maybe adjourn.
38, 39.
Lordship. Same.
Item 38, 39, I prefer sometime to my lord have the inspection.
No, she is taking time. Why do you take that? You enjoy the time.
Item 39, lordship, I am appearing. I have instruction not to press the petition, lordship. I may be allowed to interrupt. 39.
Mr. I. Hassan, Land Counsel for the petitioner, states that in WBC 375 or the states that there is an instruction from the writ petitioner not to proceed this writ petition in the present form any further. In view of such statement, writ petition stands closed. However, liberty granted to approach again if so advised. E2 order of 38 or
40, 41.
40. Yes.
Lordship, kindly pass about the matter for time being, lordship.
See, any other day, we have discussed our affidavit, we have filed it.
On the prayer of the parties, list again on take whatever date.
42.
In the last of this, the record was called for.
Some more time. More time is it?
Prayer MSR, Decca Land Council for Assam University, further time granted to produce the records as indicated in the order of 16/8/2023. List again.
43.
Yes, Mr. Air.
Lord, matter relates to provincialization, my lord. We referred this petition. Notice was issued, my lord, but no affidavit till late, my lord.
Mr. U. Sharma, learned counsel for the second litigation department, prays for 4 weeks time to file the affidavit. Prayer law less up to 4 weeks.
44 and 45.
Mr. Sharma, but file it.
Yes.
44 years, Madam Devi.
Lordship, on the last occasion, there was a reaction to take instruction. Lordship. Petitioner has been
Can
selected.
you file your affidavit, Mr.
No, no, the affidavit has not been filed, my lord. The
Sorry.
last occasion, the petitioner has submitted one report.
So you have filed your affidavit?
No, no, my lord.
File it.
The affidavit will, I think.
Why nowadays respondents are not willing to file affidavits? How can you decide? Then we'll deem that every statement is admitted and we'll pass the order in their favor if you don't file.
Or my lord can ask the my lord, government to take.
We don't want any suggestions. We want affidavit. They have taken a stand. We want to know what is the stand of the respondents. Unless you state your stand, we are going to accept that whatever is stated is right and pass our order.
Well, issue is, my lord, the petitioner is physically disabled.
Mr. As Task and Council Higher Education Department states that the department is not willing to file any affidavit in district petition.
2 weeks,
The consequence thereof would be applicable and the matter would be heard. Okay.
2 weeks may be given.
Already.
2 weeks time to file affidavit, prayer law, this after 2 weeks.
49.
No, why this traditional method of filing affidavit is nowadays sought to be done away with? Suppose with your oral submission here and there I decide, then he goes in appeal or goes to the Supreme Court. What will happen? First question will be asked is what was the stand of the respondents? Then again they'll send it back to the High Court. Completely procedure. Yes, Mr. Hazarika.
May I please, matter purchase a compensatory appointment, my lord, not placed before the DLC, my lord.
Not placed DLC, particulars to the GDO, same order. Mr. Saikya, same order. Place it, if not placed, if placed, inform. And GLC divorce, GLC, by requiring the application placed, it is not to be construed that this is a direction to appoint a, but for the DLC to pass any reasoned order as may be advisable under the law, taking note of all the facts and circumstances of the matter. Headline 2020
Application is pending before this matter, inspector of schools matter. He may be directed to.
So inspector of direction. Yes. Next.
Item 50.
B. Sharma.
May I please, Your Lordship, the matter may be taken up at 2, Lordship.
No.
Mr. Bhatti is at another.
No, doesn't matter. Wait now.
Yes, will be taken up on Friday next, Lordship.
This Friday.
Friday, Lordship.
This Friday is too early to be
They're not
listed.
12 next, Lordship. In between, I will not be here.
Borrow next Thursday.
Next.
Thursday.
Lordship, on Friday there is some difficulty, Lordship. The matter will be taken up after vacation. Lordship.
Right now, these are after vacation. As per for list after the vacation.
51 for orders.
Lordship's order, lordship will find at page 14.
In view of the order passed in district contempt. Notice is served. It's a long back.
Notice sub, I have appeared, Lordship.
41.
Here, Lordship, the state level scrutiny committee has already recommended the name of the petitioner, Lordship, for provincialization. Only that the along with 22 other posts. Now 23 number of the post has to be created. So we have
Mr. SMT Chisti by referring to
41 to
Boro. By referring to the communication dated 14/8/2023 states that the SLC had recommended the petitioner along with 22 other candidates, but there is a requirement for creation of posts for provincialization of petitioner.
That will take some time.
The communication 14/8/20 kept on record, adjourned for 4 weeks for further update. For update, not further.
52.
Yes, 52. Contempt. Notice is served.
Yes, ma'am.
Who is appearing? Bijoya Chaudhary. And 4 others. Who are they? And, but
Suffering from that doctor and he's no longer coming to the people.
but contempt cannot go away. You know, you have to give some reply.
But she's suffering from cancer and she's under chemotherapy. We are unable to contact her also. For last 1 year, she is not. So that is the main problem we have here.
Where is the order of the court?
Lord,
Which is
page number 10, my lord.
page number 10.
10, my lord.
Otherwise, in last order,
Claiming salary project.
and last order, locally, can you finance was supposed to file an affidavit?
Some time may be given to us.
Representation submitted before whom?
My lord, that is page number 12, my lord.
Page number 12.
Yes, my lord.
To the Commission Secretary.
Yes, my lord.
We do one thing, Mr. Gogoi and Mr. Chisti. We close this contempt petition by issuing a direction to the Commission Secretary to pass a order, whatever order he passes.
Secretary to the school education.
Secretary School Education. No point. If man is suffering cancer, somebody is doing this, he won't achieve anything.
My lord, it will be before the director, as per the order of this honorable court.
No, you said petitioner we allowed to submit a representation. Representation is made to the commissioner.
Not response 3. Who is response 3?
Otherwise, it is director.
Director.
Otherwise, director.
Either
Okay, let it
commissioner
be
or
the
director
director.
will take a decision. My lord. Finance directly has no role. One will consider only.
Heard Mr. A.W. Awan and counsel for the petitioner, also heard Mr. B. Gugoi for the respondent containers in the finance department and Mr. S.M.T. Chisti in the secondary education department. This contempt petition is instituted alleging willful and deliberate violation of the order dated 4/4/2022 in WPC 3518/2021. Initially, the contempt petition was instituted against Srimati Bijaya Chaudhary, who was the director of secondary education Assam.
No,
But it is stated that in
what the secretary?
Secretary to the Government of Assam in the secondary education department, but it is stated that the state officer is presently suffering from cancer.
Not in disease.
He is suffering from certain serious illness which prevents her from attending the office. In view of the above, we have noticed that the direction of the court is to give a due consideration to the representation to be submitted by the petitioner. The representation submitted is available as annexure 2, page 12 to the writ petition, which is dated 7/4/2022 and is addressed to, amongst others, the Director of Secondary Education Assam. It is stated by the respondents that the Director of Secondary Education Assam would be the appropriate authority to pass a reasoned order on the representation of the petitioner. In the aforesaid circumstance, this contempt petition is closed by directing the Director of Secondary Education Assam to take note of the representation dated 7/4/2022 of the contempt petitioner and pass a reasoned order thereon as per merit within a period of 4 weeks from the date of receipt of the certified copy of this order.
Deeply obliged.
$53.
Yes, Mr. Khan.
My learned friend standing counsel Shava has filed an affidavit.
You want
And
to
I
give
supposed to file his
Mr.
concurrent.
GMHR Khan prays for how much time? 2 weeks time to file a reply to the affidavit of the Seva.
After vacation.
3 weeks.
Deeply obliged.
54.
54. Who is the peer? Review petitioner R. Bopujari. What is this matter, Mr. Gogoi?
Lordship, my senior is on her list, Lordship. He is coming, Lordship.
Who is your senior?
B. Bhuya, Lordship. MS B. Bhuya. Born early.
For the respondent. The review has been prepared by the finance.
Today, what is to be done?
Lordship is fixing for final disposal.
On the prayer, no, last order on the prayer of Mr. Gogoi list again also. So that is
Because they have preferred, my lord, for vacation of the interim order. In review, my lord, vacation otherwise. So Lordship has stated that we will consider.
But definitely.
On a hearing day, if not inconvenient, my lord. Will be more.
on the prayer of the parties list again also.
55.
Yes, Mr. Yeah. What is this review? Review of which order on what ground?
One of the in this order melody.
On what ground?
It is observed that melody the respondent number 3 is a minor melody, whereas melody C was a major melody, but the unmarried daughter of the melody, the first wife of the melody, deceased husband.
No. Why do you need a review of the order?
If as she has been stated to be a minor melody.
No, you can file an application for correcting that to one word. But why do you need a review? Review is recall the entire order. Correcting is one mistake here and there, you rectify it. Why do you need a review for correcting one word?
Several observations have been made as minor.
So, which observation is wrong, requiring a review?
The observation that it has been said the daughter through the first wife who is still a minor is the respondent through MS so and so. So as she has been stated to be minor, my lord, your authority is not passing out on that ground.
Who is stated to be a minor? What is it? The devil arrives at a conclusion that the petitioner is entitled to family pension of Punyo Singh Moran. Necessary order be passed as regards the entitlement of the say, who is stated to be a minor. Let the defendant say after verification it is found he is not a minor. Why do you need a correction of the order?
That is there, my lord. They have this.
This review application is instituted on a premises that certain observations were made in the order dated 27/9/2022 in WPC 6392/2022 that the respondent was Sri Sompa Morong was the minor daughter of the deceased. It is stated that on fact respondent Sri Sompa Morong is not a minor. However, we have noticed from para 7 of the order that it is for the deputy commissioner to arrive at his conclusion on the entitlement of the writ petitioner to family pension. And in doing so, the entitlement of the respondent Sri Sompa Morong, who is stated to be the minor daughter of the deceased through the first wife, is also to be taken note of. As the order requires the deputy commissioner to pass an order, the deputy commissioner may make a factual verification as to whether Sompa Morong is a minor or not, and thereafter pass order. Whether or not Sompa Morong is a minor or major, but the fact would also remain on the entitlement of a daughter of the deceased towards the family pension, and the deputy commissioner shall take note of the same while passing the order. Review petition closed with the aforesaid clarification.
56.
43.
43.
Only GPF amount has been paid.
Okay, we communicated.
You just okay.
Is the order coming? BD does senior counsel notice 6 weeks
as
extra
per
for
these
3 days.
contempt rules, the power is with the court to dispense with the personal bill. Lordship may dispense it till further order, till next date. The power
No,
is
we are issuing notice returnable 6 weeks. Steps registered post 3 days.
because I find that from the rules, your lordship is to take a decision to dispense it or not to dispense it. So I find your lordship may dispense it categorically. So that they
No,
understand.
it is an implied dispensation because we have not asked for personal appearance. And no one will appear without an order.
No, I understand.
Yes.
6 weeks. We'll take it.
57.
57. Yes. Where is the direction?
No, all parties are from Guwahati. I can take it within 4 weeks, my lord.
4 weeks. Yes. Steps registered post 3 days. Yes, Mr.
Page 25, my lord.
Page
Para 50.
25. Where is the direction?
Paragraph 15, page 25.
Communicated.
Yes, my lord.
Same order. Amar Khandapur. Yes.
58.
I for what purpose?
Impleading application.
Sorry.
Impleading.
In a writ petition.
My lord.
Whom do you want to implead?
The Headmaster, Bengali Girls High Secondary School, Patan Bazaar.
Is he a necessary party?
Should be necessary party.
Should be is and
No, presently, yes.
is
Initially,
and
it's not.
should be are two different.
No, it's necessary party.
Necessary party.
Necessary.
Yes.
Yes, my, we have no objection.
By this by this interlocutory application, the writ petitioner intends to implead the headmaster of Bengali Girls Higher Secondary School, Paltan Bazar, Guwahati, as respondent number 5 in WBC 2568/2023. It is stated that the headmaster of the Bengali high school would be a necessary party for an effective adjudication in the writ petition. Mr. D.K. Royal and counsel for respondents in the SEBA do not object to the prayer for impleadment. In view of the above, the headmaster, Bengali High School, Jitu Golu, is impleaded as respondent number 5 in WPC so-and-so, raised to incorporate necessary correction in the cause title, as well as in the CIS system. Writ petition likhbo, issue notice returnable 6 weeks by registered post upon the respondent number 5.
59.
Or I likhbo, I allowed. 59. Want to any affidavit file?
Yes, Lordship.
You want to give? Do you want to give reply?
In their affidavit, they said that my case has been placed before the DLC, but why my case is not recommended? It's not done by the competent authority.
DLC.
DLC matter Lakhimpur matter. DLC Lakhimpur matter.
Lakhimpur.
Lakhimpur. That point of time.
No, you produced the results of the DLC on his consideration. The respondents through the Deputy Commissioner Lakhimpur to produce the records of the DLC by which the application or petitioner for compassionate appointment was considered. Then we'll get the answer. Yes, next.
60 to 63 for hearing.
Lordship, may we please to produce order dated 28/9.
Managing committee of that LOG.
LOG. Mr. P.K. Tiwari is very.
I think, sorry.
Mr. P.K. Tiwari, I'm appearing on his behalf. He's very indisposed. He was supposed to appear today morning only. But anyway,
the matter is still live. Are we required that decision or?
No, Lordship, as per the last order.
We know. We remember that.
So if the.
And in the meantime, I think Mr. U.K. Nair also appeared.
Mr. Nair informed that his wakalatnama has not been given and he is not going to appear.
Now, which is the live writ petition? WPC 580?
580 is live.
Live.
And
what is the relief sought for in 580?
550 is deprovincialization they are seeking, which is reflected in the order.
No. Who is the petitioner is in 580?
Petitioner.
Now who represents?
Now there is no one representing the petitioner in 580. That was.
Where is Mr. SCKL?
$580 is a managing committee.
Just a minute. Can you have Mr. SCKL? SCKL. Okay, let Mr. KL come.
64, 65.
My lord, notice has been served, my lord, by a dusty to me, my lord. Lukman Ali, I am, my lord. 64, 65.
In item number 64, we have filed an affidavit today and giving a notification. So it will after tomorrow.
It is Mr. R.C. Saikal and counter petitioner has stated that an affidavit, additional affidavit has been filed in course of the day, which is not on record. List along with the said affidavit. You also take note what affidavit.
My lord, I am in 65, my lord.
65 is different.
My lord, I am appearing for my lord.
65, we have to hear it separately or together?
Separately.
Separately.
Separate case, my lord.
65,
That issue is different. I have found that their issue is not with us.
Acha, Lokman Ali could not be served. So we required it to be served on Mr. A.R. Bhuyan.
My lord, I have received, my lord.
Because
Duly served, my lord. Now I
going
have
by
to-
our past experience, Mr. Bhuyan is almost a standing counsel for Mr. Lokman Ali. So you can take notice. So now you want some time.
Yes, my lord. 2 weeks. only
Mr. A.R. Bhuyan and counsel appealing for respondent for Lokman Ali prays for 2 weeks time to file the affidavit. Pray along this after 2 weeks.
My lord. Obliged.
66
Mr.
for.
Mr. Kial. You are the president of LOZ India School?
Proposed to be lordship, but this one got a state bank.
State. Your appointment is state.
Yes.
In which rate petition?
Lordship, this petition number.
Petition number 5239/2022.
Who has challenged your appointment?
Some 4 persons, they said their name were provided by the, forwarded by the principal, but their name were not considered.
Tell Mr. Tiwari, best way to decide this issue is, we first decide Mr. KL being appointed as the president. If we approve Mr. KL can be the successor in interest of this writ petitioner. And we'll have his view when we close it. Otherwise, what to do? Some 5 years back, managing committee had assailed the provincialization of this school. That managing committee is gone. Time to time, they appoint various learned senior counsel for 1 day. Very next day, the appointment is again withdrawn. We are very unhappy with this approach of a litigant. You cannot dishonor a learned senior advocate on every subsequent date. Today you appear, the learned senior counsel will come. Next day say, I'm not engaged anymore. This can also be viewed to be a contempt also. Maybe a situation will come, whosoever had signed the affidavit in this writ petition, we may ask him to be arrested and brought before the court for playing with the court in this manner. To avoid that unsavory situation, as that is a writ petition by the managing committee, we take note that this is under successive seal and signature. So if you are the present managing committee, we'll ask your view. If you assail the provincialization, we'll hear you. If you do not assail the provincialization, we'll close the writ petition. What else to do? For the last, I don't know how many years, almost 9 or 10 years. And almost every respected learned senior counsel was engaged once or twice. And this is not fair. So let us decide your writ petition first, challenging your. And once we have you as the president, we'll hear you directly. Because after we took up under submission Mr. P.K. Tiwari and sent a notice, Mr. U.K. Nair appeared. He said that I have the instruction. Today he is saying that instruction is again withdrawn. Are these people not playing with the court for the last 10 years? Whosoever is it, we request you find out his name and send him a warning that if he stops this, if he does not stop this misbehavior, we are going to issue a warrant against him for playing with the court. Repeatedly, this is the 4th or 5th time it happened, a learned respected senior is engaged. By the time the senior wants to say something, he has to face the embarrassment, say, I'm taken out of this case. What is this behavior? Not proper. If you challenge provincialization, if you have a good ground, argue it out, we'll decide it. If you don't have, we'll dismiss it. But what is this? Playing around with the reputation of the learned senior counsel in this manner. And not just one. I'm not naming everyone. Please take up with this man. Who is this man? File to sound. Who had sworn this affidavit? Let us see. Which writ petition it is? 580, yeah? 580. Ramesh Kumar Jain. Is also an advocate. R.K. Jain, Ramesh Kumar Jain. No, ask him to remain present. Son of Jhumarmal Jain, resident of SRCB Road, Panbajar.
He is an advocate practicing.
He's a respect. 580 likhibo. It is noticed that this is a writ petition pending from the year 2013, assailing the provincialization of the LOG Hindi High School at Fancy Bazaar. The disturbing factor is that repeatedly learned senior advocates are engaged in the matter, and when the matter is about to proceed, the learned senior counsel would state before the court that he had been withdrawn from the case. The last of the occasion happened with Mr. U.K. Nair, learned senior counsel, who appeared before the court on 19/9/2023. Today, when the matter is called, it is stated that Mr. U.K. Nair had also been compelled to withdraw from the case. It is noticed that the affidavit in WBC 580/2013 has been sworn by Sri Ramesh Kumar Jain, son of Jhumarmal Jain, resident of SRCB Road, Guwahati. Sri Ramesh Kumar Jain to remain personally present before the court on the next returnable date. Whatever it is, as he is the affidavit holder, let him remain present. If he wants to engage a learned counsel, pursue, let him do it, or else we close this petition. We can't allow the reputation of a senior counsel to be played on in this manner. Response when so. A copy, a registry to communicate a copy of this order to Sri Ramesh Kumar Jain.
Perhaps the Lordship is taking up this petition.
Which one?
The new one, my lord, 5239. 5239.
Item number?
Latest one.
63. 63.
Appointment of the newly constituted committee.
Mr. Kale's appointment. Yes. Why do you challenge Mr. Kale's appointment? He is a very, very respected person. What is wrong with Mr. Kale?
Yeah, this case actually fixed on 9/10.
But it is listed today.
Listed today along with this.
Actually, that is good enough. Listing is good enough for the court to take it up. Why do you challenge?
Challenge because Lordship, 4 names were forwarded as per.
By whom?
But it's not the inspector of the schools. They asked me to hold a meeting, select the person for constitution.
Whom do you read? Who is Devanand Singh?
Devanand Singh is the presently selected by the local people and guardian to become a president.
What enforceable legal right a person has if he is recommended by the public?
Lordship,
see, Mr. Barhuya,
before
you address, we are telling you the law is the inspector of school in consultation with the parent and guardian will recommend 2 names for the president in consultation. In that process, the inspector will consult the guardians and the public.
Principal and the headmaster.
They may recommend somebody. Again, it is for the inspector now to either accept those 2 names or give to some other names. The 2 persons who were recommended has no legal right. No right flows in their favor. Just because the public had recommended their name. Because the appointing authority is the process will be initiated by the inspector, go up to the level of the director, appointment will be made by the deputy commissioner. That is the procedure. So in this consultation process, if any name is recommended by the public, that no legal right flows to that man, that it will I only who can be the president henceforth. Please explain on that legal issue.
That's why last August I prayed some time and then Lordship fixed on 10, 9, 10.
You want to explain on 9-10?
On 9, 10.
But otherwise, why should we hold back?
That's why today, why
See,
other cases listed. on
otherwise,
my-
why should we hold back a respectable person like Mr. KL from discharging the duties of the president?
But the people,
See,
yes, Lordship.
Mr. KL had openly stated he has no personal desire for all these things.
Lordship.
Only thing, a responsibility is given to him and he wants to undertake the responsibility. He is not one Devanand Singh, that he who wants to become the president.
Yeah.
Why should that man should not be? Knowing the reputation of Mr. KL, it will be good for the school if he takes up. We don't see any public interest in favor of Devanand Singh. We don't see any legal right in favor of Devanand Singh. You address on these two issues.
On 9, 10.
9, not today.
Today.
On the prayer of Mr. F.U. Borbuya, it is adjourned to be listed on 9/10/2023. On the next returnable date, the Learned Counsel for the petitioner shall first establish as to what legal right Devanand Singh and others have to claim to be the president of the LOG, to claim to be the president of the SMDC of the LOG Hindi High School. It is stated that the public and the guardian in their meeting had recommended the writ petitioners. The procedure to be followed is that the inspector of school, upon with consultation with the parents and guardians, shall recommend 2 names, which is to be approved by the director, and thereafter appointments are to be made through the deputy commissioner of the concerned district. In the process of consultation, if 2 names are recommended by the parents and guardian, what mandatory legal right remains in their favor that it is only they who can be appointed the president and not anybody else? Secondly, the writ petitioners to also explain what public interest to be served if it is only if only the writ petitioners are appointed as the president and not the respected person whom the inspector of school now proposes to appoint as the president. Response for the hearing.
Item 35, my personal affair. Deputy director issued public as a public information.
Take it up with the court master. We'll change the name. Change the name. We'll do it. Yes. Next time.
Here the consultation. Just clarify one thing. The consultation is with the principal, headmaster, and local people, not parents and guardians.
But he is saying.
No, the rules is. Your lordship is referring to the
consultation with the principal.
Principal, stroke, headmaster, and local people.
The schools are again made another battleground for these political activities.
Matter pertains to compassionate appointment. Page 13 is my application.
Say application.
Yes, madam.
Not placed.
Not placed, madam. I have not been informed, madam.
Same one.
Madam.
Same order, place it. If already placed, inform. And Aru logot at a line. The requirement to place it should not be considered to be a direction from the court to appoint, but the DLC will consider application on its own merit as per law.
67.
Mr. Saikia, some of our orders are misinterpreted. When we send it back, you recommend saying it's as per the High Court order. We never ask you to recommend somebody. We only ask you to consider it as per merit. You don't do that. Your DLC is like a pendulum. Either arbitrarily reject it or arbitrarily allow it. The true assessment is not there any other way. Never do that. That's also a contempt in another manner.
The impugn order is my lord at page 51. is issued in during the operation of the
Page number
51, my lord.
51.
This is issued, my lord, in operation of the interim order of this honorable court, page.
Just a minute. Is partial modification. This is the impugn order.
Yes, sir.
Why? What is wrong with this order?
My lord, page 50, my lord, your lordship will find paragraph 10. The interim order is there, allowing me to continue as in charge headmaster, my lord, as per order dated 17/8/2022.
Page 50 is an interim order.
Yes, of this honorable court in earlier round of litigation, my lord.
Who is the petitioner here?
Same petitioner.
That Mezazul.
Yes, sir.
Where is the order allowing Mezazul to be in charge?
Page 50, my lord, last paragraph.
Why this order cannot be passed?
My lord, I'm continuing as per order dated.
No, understand. You read the last para 10 once again.
As the earlier impugn order.
Since the order dated 17/8, that is giving you the say, had not been recalled or superseded by the in charge DO in her impugn order dated so and so, same shall remain. For it's a conditional order, meaning thereby, if it is superseded, no one has determined the legal right of the petitioner to be the in charge. It is only say that the order allowing the petitioner to be the in charge had not been superseded. So therefore it will remain in force. It's a clarificatory order.
Yes.
And that clarification they act upon, now they feel, yes, we'll supersede it by another order. There is no prohibition.
My lord, I'm the senior most teacher of the school, my lord.
That is your being senior most is another legal right.
Yes.
But you are urging upon only on the basis of para 10. Para 10, we say that this is a conditional order or more or less a clarificatory order that since the order allowing you to be in charge had not been superseded, so you will continue. Corollary to that, if it is superseded, you will not continue. Now they issue an order superseding you. Where is the illegality?
That is I'm challenging this, but I'm the senior most teacher of the school. I'm holding the post of the.
Okay, you are challenging on the basis of senior most.
I'm the senior most teacher of the school.
Then you argue out in that line that you are the senior most. Which document will show you are senior? You are senior to Lipika Sinha.
Page 42 itself, my lord.
Mr. Purokayasta, there must be some reason why your petitioner, they don't want him to be the in charge. Something must be there. So initially, they, without superseding your order, they allowed the in charge BO to be the in charge. That was interfered.
In the earlier case, my lord, the BO, we have made allegations against the BO, my lord. BO has made some misappropriation of funds.
But possibly there is some reason why you are not wanted. The respondents in the elementary education department to inform the court as to why the order dated 14/9/2023 was passed, allowing Lipika Sinha to be the in charge
Not
in charge to act as the member secretary of Janata ME School.
Nandini.
And by superseding the earlier order dated 17/8/2022, by which the writ petitioner was the in charge member.
Yeah.
List on next week. Let us see then. If there is no good reason against you, we'll state. But if there is some reason, then we'll have to look into it.
68.
Yes, Mr. Bikelas.
My lord.
Is this matter?
Here, my lord. Initially, my lord, the petitioner was given admission in the Tezpur Medical College Hospital. And
This is a MBBS examination.
she was granted already, and thereafter pursuant to the court order, my lord, that re-verification was conducted. And in the re-verification.
Okay, we'll issue notice.
Because on the basis of earlier admission, I was continuing.
Then you discharge the burden, which forefather of the petitioner was a tea garden laborer.
My lord, I place it before the committee, my lord, during the re-verification. My lord, page 64.
64.
Yes, my lord. It is in the name of the Durbal Kurmi, my lord. It is in the name of Durbal Kurmi, my lord.
Durbal Kurmi.
Yes, my lord. And my lord, Durbal Kurmi is my grandfather, my lord.
Office of the Assistant Executive, PWD Rural. What is this PWD Rural?
My lord.
How PWD Rural and tea garden laborer are connected?
My lord, I am not getting the page, my lord, sorry.
Which page you are relying on?
64, my lord.
Where is 64? Before 65? 64 has to be the page before 65.
My lord, that is ABCD.
ABCD. Why you write all this? Where is 64 now?
My lord, Annexus 16 dated 21/9/2023.
No, there is 63A. Then
I'm sorry, my lord. That,
Mr.
After 63.
Thus, after page 63A, we have 164B. And where is 64 now? Please find out. Call the next item. Find out where it is.
69.
69 is also not here.
Your matter. Yes. Are you 69? That one you check up the page number.
Mother, here also, mother.
Same.
The petitioner was given, mother, admission on, mother, 7/9.
Mr. Gugoi, I think we delivered one judgment. How does TGL will be determined? That judgment is still there, or it is appealed or stayed or something?
No, my lord, this final order, my lord, that is at page.
No, 72. Our judgment.
Yes.
Providing for the procedure how TGL will be determined.
That has been not put to challenge.
That is not put.
Subsequent order, whereby my lord, they have been directed to cancel, my lord, their seats pursuant to the inquiry report.
That is different.
Yes.
That is on facts of one particular case. The general provision is still remains. So,
So far, my lord, one thing may I submit, my lord. So far as the present petition is concerned, my lord, it's not maintainable because of the fact that, my lord, there is already a direction of this honorable court to cancel the admissions of those persons who have found to be not eligible for that particular quota.
Definitely, that's a general order.
That order is already there, my lord. At best, the petitioner can challenge the inquiry report. Only in that case, lordship can examine whether the report is genuine. Some, my lord, there is anomaly in the report. It is not on the challenge.
To answer that, my lord, submission, my lord.
No, Mr. Das, we are basically interested in the core issue. This is a reservation given for the benefit of the tea garden laborer and ex-tea garden laborer people, not for others. There is a huge confusion because all along the OBC notification provides entry 24 to be TGL or ex-TGL. As enlisted below, containing 96 different communities. Till now, the only determination for issuing the certificates was whether you belong to the 96 communities or not.
Yes.
No one bothered to find out whether you are a tea garden or ex-tea garden labor community. So we have passed a judgment that the first consideration is you have to be TGL. Second consideration is you have to be amongst the 96. So we require the authorities to make a determination whether a given candidate belongs to TGL, ex-TGL or not. And the only means of determining is one of your forefather has to be a laborer in one tea garden in Assam. Now, if you are disputing all these aspects, provide us the material which forefather of this petitioner was a tea garden laborer in which tea garden. We'll get that fact verified from the authorities.
So far, this present petition is concerned, page 68 and 69, these are certificate issued by the.
And what is a certificate, Mr. Brigadier? What do you understand by a word certificate under the law?
Because this
no, please reply. Under the law, what do you mean by the concept certificate? What is a certificate?
Authentication of
nothing. Certificate is a document by which the author certifies the existence of a fact. Right. That's all. Nothing beyond that. That is what is called a certificate. So once you have a certificate in your favor, we are bound to look into, in the background of these cases, whether the existence of the fact do actually exist or it does not exist. We are asking you only that question. Existence of a fact is one of your forefather must be a laborer in a tea garden, either today or in the past.
Yes, ma'am.
Give us the name of the laborer, give us the name of the tea garden, we'll get it verified.
So far, this case is concerned, this is for TGL. And another case was for ex-TGL. And so far the TGL is concerned, her father worked in the garden, the petitioner's father.
What is the name of the father?
Raju Satnami.
Raju?
Satnami.
Satnami. In
Yes,
which tea garden he worked during which period?
Khorasan Tea Estate,
Khorasan Tea Estate. Yes, Mr. Dhor. Are you there as a respondent?
No, my lord, here but report will come from.
So, Deputy Khorasan Tea Estate is in which district?
Is in Soraido.
Huh?
Soraido.
Soraido. Ask the Deputy Commissioner Soraido to send a person to Khorasan Tea Estate, find out from their records of the laborers maintained whether this person was ever a laborer there.
Worker.
Not a worker, laborer, mind you.
Yes.
Because tea garden has different kind of workers.
My lord, that report has already been relied by the scrutiny committee. Scrutiny committee has already submitted.
Already submitted. What the Deputy Commissioner says?
Certificate issued by the manager. This report clearly states that father of the applicant was not working as tea garden.
So you challenge the report first.
And this
no, you challenge the
was,
report.
Yes, my lord. This report was not furnished to us, my lord.
No, it did not be. There is no natural justice. Mr. Das, if you want, please hand over that
Yes,
certificate to Mr. Das. You challenge that report.
Yes.
We'll entertain it.
And so far, this Satnami community is concerned, my lord, page 29, my lord. That is enlisted.
Mr. Das, Satnami community may be enlisted,
yes,
but that member of that Satnami community must be a laborer in a tea garden. That is not established. Satnami is established. We have no difficulty in understanding that. So we challenge that report. Mr. P. Saikia, Learned Counsel for the Deputy Commissioner Soraido, produces an inquiry report dated 26/9/2023, which provides that who is not a laborer? Name of the person.
Raju Satnami.
That Raju Satnami, who is claimed to be the father of the petitioner, was not a laborer in any of the tea gardens in the district. The petitioner, if agreed, may seal the inquiry report. List again. See, otherwise it's a constitutional fraud, Mr. Das. People for whom the benefit is given is not getting. People who are obtaining certificates from here and there are usurping the benefit. Next item.
Malad, that first item also, Malad, that name will be Malad, grandfather of the petitioner Durbal Kurmi.
There also you challenge the inquiry
Yes,
report. We'll call for the records why it is said so. We'll decide it. You challenge? Whenever you challenge, it will be listed.
Yes.
Agree. 70 and 71.
Wait, please, Your Lordship. Wait, please, Your Lordship. Your Lordship, I appear for my senior item number 70. Item number 70. Yes, there's an IA.
Item
number
70.
We were served with the reply from the applicant yesterday, Your Lordship. The engaging counsel is also not here.
Applicant who intends to get the order vacated.
Yes.
Had filed an affidavit yesterday.
They filed an affidavit yesterday.
You want to examine the affidavit?
We want to go through the affidavit, Your Lordship. A small time frame may be granted to us, Your Lordship.
Which case? Your case?
Item number 70, Your Lordship.
Mr. M. Sharma, learned counsel for
the petitioner in item number
for the
70.
writ petitioner in WPC
1635
1635
of 2020.
seeks for a short adjournment to examine the affidavit filed by
the applicant in IA 24.
filed by the applicant in IA 2468/2023. Pray aloud, list on a very short.
Very short.
Only one thing, there are two IAs.
So therefore we use the case numbers.
Yes, ma'am. So that IN 1984 can be taken up.
In fact, both the IAs are for vacation of one interim order, which
No,
Your
that is
Lordship
all
has
right.
granted.
Issues are different.
Issues might be
They are the clients of my friend and Kaushik Milo. They are same in the same subject. Assamese matter. I am from totally different minor field. Science
Okay, the
subject.
subject matter does not include this your client,
Yeah, yes, ma'am.
but stay order is operating
Yes,
against
ma'am.
you. No. If the writ petitioner does not have any claim over the post of Mr. Goswami's client, then I think a stay order should not operate against him.
Exactly.
That in fact,
My subjects are
Just take up that aspect. Suppose we allow the writ petition, even then this person will not have any claim over the post of Mr. Goswami's client. Then unnecessarily he should not be restrained. But if you have,
I'm also a respondent only, Mela. The writ petitioners are there.
do you have any, what claim you have to the post occupied by Mr. Goswami's client? What legal right you
I
have?
apologize before this court, Your Lordship. In fact, I am only standing in place of the engaging counsel.
Mr. Goswami, we are for 2 days.
Just a short.
He is expressing his personal inconvenience. We can't force it on
I'm
Mr.
grateful to my
Sharma.
senior friend. I'm grateful to my senior friend. Any short date.
Short date at the we'll hear it all.
I'm grateful. I'm grateful.
Item 72 for admission with personal appearance.
Have you filed your affidavit?
Lordship, no. So I asked him as directed by.
We said either affidavit or personal.
appear
Why
in
don't
the-
you file the affidavit?
But Lordship, after going through the documents from the director, it appears that there was some mismanagement by the subordinate officer. The instruction, though he signed it on 20th September, it has not been forwarded to us.
It did
Now,
not, it was not.
forwarded to us.
Means the director had done his work.
Yes,
but some
Lordship.
subordinate had.
Some mismanagement, Lordship, it was not communicated to us.
That resulted in this situation.
Yes, now I have received it, but in spite of that.
Yeah, it's stated by Mr. B. Chaudhary, Land Counsel for the Director of Education, BTC, that the director had issued necessary instructions enabling the department to file their affidavit. But the said instruction was
Was not communicated.
Was
to
what
us.
what word you used?
Mismanagement,
Was
Lordship.
mismanaged by some subordinate authority in the department, which resulted in the instruction not reaching the learned counsel. The explanation is accepted. Mr. Chaudhary says that the affidavit will be filed
Lordship, 1 week.
within a week, re-allowed, list after 1 week. Appearance of the director is dispensed. If it was a matter of some subordinate authority mismanaging the instruction from reaching the learned counsel, the director is requested to make an inquiry on the same, take appropriate action, and ensure that in future such mismanagement by the subordinate authorities do not take place. You take action against him, whosoever has not done his work. Action doesn't mean dismiss. At least a warning. You'll find one more repetition, I'm dismissed.
73.
73. Yes, Mr. Arun.
May I please, my lord, it pertains to a compassionate appointment, my lord. His father expired in the year.
Was it placed before DLC?
No, my lord, that was not placed, my lord.
Not placed.
Not placed, my lord. I have
Yes,
applied.
Mr. Pass the same order, not placed, place it.
My lord. Also communicated, my lord, with the department.
No,
my
Mr.
lord.
Sakya, what do you say? Same order.
My lord.
Same order to lichibo. Last but khali hetu dibo. It should not be constituted to be a direction. And if already placed, no further requirement, petitioner to be communicated.
My lord, only one thing, my lord, your lordship, may I have applied within 1 year, my lord. From the
We are not deciding your application. DLC will do whatever is required to be done.
74 for orders.
Yes. As per office note dated 3/10, notice is written answer from respondent number 5 and 6.
Want to take first steps? In view of the office note dated 29/9/2023, 3/10/2023, the petitioner to take first steps on the respondents number 5 and 6 by registered post as well as by trustee method through the registry of the court and thereafter file affidavit. List after 2 weeks.
Time being item 1.
I'm sorry, madam.
Mr. T.K. Bhuya, learned counsel for the petitioner, states that there is an instruction from the writ petitioner not to pursue this writ petition in the present form any further. In view of such statement, writ petition closed. However, liberty remains to approach again if so advised. Baki sobore appearance to DDO.
Interim order is there.
Interim order stands vacated. Mr. Bhuya, we cannot withdraw on the prayer of a council whose name does not appear.
Because my lord, I struck in rail gate, my lord.
Whatever it
My
is,
lord,
that will be
I apologize.
There we start, it will be a disaster.
My lord.
Anybody can come and make an application, please withdraw this petition.
My lord.
And next day, the actual council will find my petition is not there anymore.
Next time I'll be.
And in fact, as a lawyer, it happened with me once.
My
So I'm quite conscious. One day I make a mention for getting my case listed. After some few days, the registry informed me, your matter is already closed long time back, withdrawn by somebody. And then an inquiry was made. What happened? A counsel for another item had mentioned the wrong item, got it withdrawn at the motion. That's why I don't allow it at 10:30 also. At 10:30. So my petition was withdrawn. His petition, which was sought to be withdrawn, remained on board. So avoid all this.
My lord.
Make it more straightforward.